Okay, I always found this utterly ridiculous. All right, remember I was talking about informed consent, how you need reasonable knowledge. Anyways, you need reasonable knowledge to give informed consent. Quick and speedy trial refers to a criminal trial that is conducted promptly with minimal delay, adhering to the constitutional right to a speedy trial as outlined in the Sixth Amendment of the U.S. Constitution, essentially meaning the trial should begin within a reasonable time frame after charges are filed. Key point about a speedy trial: legal basis. The Sixth Amendment states that an accused person has a right to a speedy and public trial. Speedy Trial Act, federal law known as the Speedy Trial Act of 1904, sets specific time limits for different stages of a criminal prosecution to ensure a speedy trial. Courts evaluate various factors to determine if a trial is considered speedy, including the length of delay, reason of delay, whether defendant asserted their right to a speedy trial, and a potential prejudice caused by the delay. Now that's the part I always had a problem with, whether defendant asserted their right to a speedy trial. Most people don't even know they have a right to a quick and speedy trial. I've seen people, I was on television when the coronavirus started, some guy was crying that he was in Cook County Jail 2 years waiting for a trial. 2 years. Okay, people also ask, what does it mean to have a quick and speedy trial? Simply put, a prosecutor must case to trial within 60 days of arraignment unless there is good cause for delay. Wow, I bet you didn't know that. What is the right to a speedy and just trial? In all criminal prosecutors, the accused shall enjoy the right to a speedy trial, public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have previously asserted by law inform the nature of the case and accusation. Why would you waive your right to a speedy trial? The most common reason for waiving the speedy trial is to give the defense more time to prepare their case. If the defendant faces serious time, if convicted, taking that time to let your attorney be prepared as possible can be very well be worth a couple of months in jail. Yeah, well, people are spending a couple of years and without even knowing they have a right to a quick and speedy trial. What is the reason for a speedy trial? One reason that does not guarantee a defendant receives a speedy trial is that passage of time between arrest and trial can be used by investigators with the district attorney office to continue identifying additional witnesses and strengthen their case against the accused. But that rarely happens. And you know why there's so many delays? Failure to expedite litigation. It's mandatory to expedite litigation, and that basically means your lawyer gives any information they have, the state's attorney in turn gives over the information they have. Now, if they were diligent, which is required in the rules of professional conduct, they would do that on the first day. It's mandatory that you be allowed everything that's in their file. It's called discovery. Okay, so state's attorneys are well known for not expediting litigation. Your own attorney will fail to expedite litigation. What is required for evidence to be admissible in trial? Admissible evidence is what purports to be it is genuine and not fabricated, contrived, forged, or materially altered. How does a judge decide whether or not a trial is speedy? Test requires a court to consider the length of the day, the cause of a delay, the defendant's assertion, his right to a speedy trial, and the presence of absence of prejudice resulting from delay. A lot of people I helped, I used to go to the criminal courts, and tell them, as soon as you walk in, ask for a quick and speedy trial and a jury trial, and the case usually gets thrown out on no probable cause. It's just, they won't do it. State's attorney won't do it. Public defenders won't do it. If you don't demand it, they won't do it. So basically, there's a lot of laws that I'm showing you that you got to know, okay? Because ain't nobody going to tell you, even though in the rule of professional conduct in the preamble it says they're supposed to tell you this, but they don't. Okay, which of the following is an argument against a speedy trial? An argument against speedy trial is that they may not give the defense adequate time to prepare. But if everybody abides by the rule of professional conduct, code of judicial conduct, they have time to prepare. What is an indictment in simple terms? An indictment means that a grand jury, not a prosecutor, has filed criminal charges against you. Indictment and criminal charges must be proven against you beyond a reasonable doubt. It's not a conviction. You can't use as evidence that you committed the crime charged, okay? Should I waive my rights to a trial? It might be advantage for a defendant to waive their rights to a jury trial for several reasons. These include previous to public sentiment in high-profile or contentious cases. Opting for a bench trial can circumvent the potential influence of public opinion on a jury. Judges, if I can't trust a judge to abide by the code of judicial conduct, there's no way I'm going to trust a judge to judge my trial. Which of the following is most common result of criminal cases? Guilty pleas. Nearly 90% of federal cases are resolved by guilty pleas, and that's because they're usually advised to. A lot of times, this one kid I went and saved, the last one, since his handicap status kicked in, I don't go to the court like I used to. But this kid, he got arrested. The judge didn't want a probable cause hearing. State's attorney didn't say nothing. The public defender was pissed off because I had the kid ask for a probable cause hearing. The judge said, I know where this is going. This is going to trial. So he sent it from 51st and Wentworth to 2016 California. The public defender, when he walked in, said, here, sign this and you can go. The kid said, oh, really? So he was going to sign and leave. I said, no, you're going to leave here with a felony. He said, what? I said, yeah, you're going to leave here with a felony. You ain't going to be able to get a job asking you want fries with that. And the public defender says, no, that's not true. Another kid I stopped, I says, hey, remember you wanted to go to the military? He said, you won't be able to get in the military with that felony conviction. What do you mean felony conviction? He said, it's misdemeanor, right? She said, no, it's a felony conviction. He said, why would you want me to sign that? So he asked for a jury trial. He asked for a quick and speedy trial. And they wouldn't give him a quick and speedy trial. Tried to talk him out of a jury trial and told him to go with a bench trial. And if he just signed all this paperwork and then he could leave there on probation, he decided to go for the jury trial. He picked his own jury to make sure there weren't any public servants on there, cops, lawyers, judges, what I call the thin blue line effect, the code of silence. All public servants keep a code of silence, and this is part of the code of silence that I'm telling you about. I'm saying the quiet part out loud. So anyways, they went to trial. The only witnesses they had was a cop, and they arrested on the second kid that was supposed to go to the military. So anyways, they arrested 7 kids. They already had 6, they'd already 5 that signed a paper for a felony conviction. They didn't even know they had a felony conviction. The other one, he wound up with a public defender. The public defender talked him into pleading guilty. So they had 6 convictions on this case. So anyways, the only witness they had was a cop and what was on his police report. So they questioned the cop on the stand, and asked him how many people he's seen spray painting. He said he's seen all 7 of them. Basically, they waited till he pulled up on them from several blocks away, and they all stood there. And so the kid gave the public defender the line of questioning, and one of the questions was, in the police report, there was 2 cans of spray paint. Which 3 held this can of spray paint, and which 4 held that can of spray paint? The judge called for a sidebar. They all went into the judge's chambers, came back out. The judge excused the jury and apologized for wasting the time. Didn't cite the cop for giving false testimony, perjury. You know, any testimony he started to give was in conflict of what he said in the police report. Couldn't be proven, but they threw the case out. They threw the case out and spent 9, 10, 11 months trying to convince the kid that he should just take a guilty plea. All right, so, but when you know your rights and you know the right questions to ask, and, you know, I said you basically got to be a lawyer to get effective assistance of counsel in court, meaning somebody that's going to abide by the rules and play by the rules. The only reason I win and people say I'm lucky, I'm not, is because I always play by the rules and the codes, and nobody else does. And I bring it up, and it makes it an easy win. But it ain't over, because you have to look up the color of law. Everything they did in that courtroom was illegal. He thought it was legal. You would think it was legal because this is lawyers and judges doing it, but it's not. So that's under the color of law. So you would have to look up deprivation of rights under the color of law. And that's another subject. And conspiracy of deprivation under the color of law. That's another thing you should look up. Okay, because they're all combined, but they're all different. And that's what happens to everybody. You know, that one kid that they sent it to 26 in California, and they spent about the same time, 9 months, a year, trying to convince the kid that he had nothing coming and just take the time. And they did it to him twice before, but both times he signed the paperwork, not knowing what he was going through. So I stopped him from signing the 3rd time, because I didn't want the 3 strikes law to kick in, because they would have let him go from court that day, but they would have came back later and got him on the 3 strikes law and gave him extended time. Okay, so it's just what you know. It's just what you know. And he didn't know much, but I sure made sure he did, tried to anyways. But they did throw the case out, you know, no probable cause. Okay, was it right, waiver right to a speedy trial was considered a fair trial, you know, playing by the rules, the codes, being effective assistance of counsel, you know, that, so this is an opening, it's freezing up again. Anyways, just stop by. You got the tools right there. Your phone, the internet. Look up quick and speedy trial. You know, you didn't have reasonable knowledge to make an informed decision, to give informed consent when it came to a quick and speedy trial. Okay? And that is required before proceedings can move forward. Okay, I'm going to make this as short as possible, but I just wanted you to know what you are up against, what we're all up against, what we've always been up against, living under the color of law. Good night, or good afternoon.